RRB shall send all recruitment related communications only through SMS and email till the recruitment is completely over. RRB will not entertain any request for change of mobile and email address at any stage.
So you sent it by
SMS.
SMS. That failed or that was delivered? No, where have you said this in your reply? Let him complete. What was your stand about the failure? So if there are two methods given of communication. One is SMS, the other is email. Did you go in for email? Then why have you filed this petition?
SMS was sent and all more than 95% appeared before the and all the messages were sent and he received the all messages except this one. But at the time of PET, he was well aware that within 2 or 3 days he have to visit the for the document. Once he appeared in the physical examination test, at that time also he was well aware with the fact that he will have to bring the documents.
No, the mode of communication is there are two modes. One is SMS, the other is email. If one method fails, then you have to adopt the other method, or you can say that I will not adopt.
Not a single mail was sent to anyone.
Why not?
And that when we sent the messages, we were not aware whether it was failed or delivered. So all the information was available on the website.
You are not supposed to ensure that there is no failure. SMS. How do you get the report?
Downloaded the
इसका screenshot है क्या?
screenshot वो फिर फाइल किया आपकी page 44 पर इसका document
44.
the additional document. Yeah, 44. 824.
44.
Yes.
Prediction?
Part number exam R3 part.
Part number 3.
R3 part.
RJ3. Main petition में.
Additional documents. Additional documents.
Documents within 54.
Covering remote, sir.
44.
Additional documents. अच्छा सर
30. 30 तक तो है इसमें. उसके बाद कवरिंग मेमो.
कवरिंग मेमो सर.
कवरिंग मेमो यही वाला है.
Yes. 44.
Compliance from code order में फाइल किया वाला document address.
Yes.
Yeah.
Yes.
ये तो आपको भी पता होगा ना कि फेल हो गए.
नहीं सर ये हमको सब जानकारी नहीं थी कि हमने हजारों मिनट से सेंड किए जो इंडिविजुअली फॉलो करना डिफिकल्ट होता है.
When you come to know, you rectify the defect. क्या यही तो बोला है ट्राइब्यूनल. Even giving is not that he's yet to, he has already passed all tests.
Once he appeared in the physical examination, well aware कि हमको एक हफ्ते बाद उसमें आना है जिसके बाद वो रिजल्ट ही नहीं देखा.
No, तो ऐसा कोई इंस्ट्रक्शन है क्या?
थोड़ा ऐसे में फिर क्या हुआ कोई रिक्रूटमेंट कंक्लूड ही नहीं हो पाया.
वैसे you mean ऐसे failed reports और भी बहुत सारी होंगी. They will come forward.
अगर विजिलेंस ऐसे बाकी बाकी सारी चीजें तो इसने वेबसाइट से ही डाउनलोड की.
No, but why was this? Why was filed when?
Immediately, during the process, it was filed on interim order was passed.
But sir, it's 18, 19 recruitment, you're coming now.
No, immediately.
It was pending for some years there.
So granted and settled on 22nd of May 2019. And one post will be carried again.
Hmm. Anything else? Yes, this petition has been filed. And the article so and so, saying the final order. Allowing the OA in question, OA so and so, which was filed by the respondent, single respondent. Single respondent, the respondent.
petition is planting the car of the.
Hmm?
This is petition is.
Petition 23 came on OA marriage. OA is of 19. Where is the OA? Where is the OA? Connection? Before.
Number 19.
This is from my own perspective.
So they rejected your candidature or what happened?
They did nothing, but I could not appear below, then I submitted a representation.
They must have sent you some communication that because of so and so reasons, we are not proceeding ahead.
They passed an order on my representation. That is the reason. I sought permission that I may be permitted to appear in the second round because I have not received that. So on that, they passed an order.
No, because you have not challenged any order.
But we were seeking direction, my lord. They communicated to me, my lord, that since you have not appeared, now you cannot be. So I find a way, my lord, seeking a direction that they should comply with clause 11, my lord. If they will not comply, then. With my documents.
Claiming the following relief. Quote. Page number 99. Next. The bare facts of the case reveal that for recruitment to the post to a Group D post under the railways. Which railways? Which railway? West Central Railway. West Railway. A written examination was held on 20th of September 18th, which was successfully negotiated by the respondent. Full stop. Thereafter, the respondent also cleared the physical proficiency test. Full stop. The date of 23rd of April 19 was fixed for document verification, which fact was communicated to the concerned candidates as per instructions dated
As per recruitment advertisement and
as per clause 11 of the important instructions by the centralized employment notice CEN number 2 of 18. date, dated 10/2/18. Wide R1 to IA to document number 4293, which reads thus to quote clause 11 only.
But there are repeated clauses, not of the same candidate, same body. Clause 11 is the main clause, that means repeated clause subsequent clause.
Which clause?
But 16.1. It will not, candidate note appended to clause 15. Candidates are advised to keep their personal mobile number and
16.1 और कौन सा है?
15 will not be note appended to clause 15. Candidates please note.
कहाँ लिखा है?
15 के सबसे नीचे से होगा.
Which page?
Clause 15.
Which page of this document?
Number 20 of my
20. में तो 20 में 16 है. 16.1.
Before that, 2 pages. 17 pages of this document they have filed. Page 17 will not. Candidates please note that they have put a box on how to apply.
As per the following clauses कर. Clause 11 हो जाएगा फिर 3 points हो जाएगा फिर वो in the page 15 पे candidates please note. That's all.
3 pages.
The case of the petitioner before the tribunal was that the SMS sent to him about the date of 23/4/19 for document verification did not actually successfully reach the petitioner, the respondent, which is evident from the failure report. That is Kahan.
it's a R3, page number 40.
40. Page 40. English table has support for next. Petitioner contended before the tribunal that in terms of the rules governing the recruitment, there were two modes of communication of information. SMS and email. Also, the recruiting agency does not dispute that the mode of SMS did not actually bear any fruit since the communication through SMS failed. Thus, the respondent contended that the other mode of email ought to have been, which was not done by the recruiting agency. Next. The tribunal, after considering both the sides, contentions of both the sides, allowed their. Next, for the. You are the recruiting agency. Who is aggrieved? The recruiting agency. Everybody. The petitioners are before this court, failing the aforesaid order of the next. After hearing the learned counsel for every party, this court is of the considered view that the tribunal was right in taking the view that The recruiting agency also have adopted the other mode of sending communication regarding the date of 23/4/19 of document verification to the candidate. Instead of not having done so, the recruiting agency failed to follow the rules by which it was itself bound. And therefore, this court does not deem it appropriate to interfere in the well-reasoned order of the judge. Next, accordingly, the petition stands dismissed.
Number 20, Rahul Chaubey, Kanak Gaharwal.
Yes. Pleadings are complete. Yes. All. Any urgency in the matter? What is the issue?
लगभग 2.5 साल हो गया है.
For appointment of staff, that's the list. It process when I was in the government, according to our, I think the practice, it was a deputation. But can you post for 3 years? Now I applied for those and after I was applied, I started functioning with them. Later I received a show cause notice saying that I do not agree with it. Why I should not be terminated, disengaged. I traveled to the court of the tribunal. The tribunal was pleased to not add interim reading to my field. The reply was filed by them. And persons felt the matter was heard. Finally, what the learned tribunal did was taking care to the scale of pay of a central government, which is a grade pay not available with state government, took that into picture and finally dismissed the court. Whereas over the advertisement, when we have a perusal, different things have been treated for us.
You are still in service. You are back to your parent department.
Another few months to go.
It's indicated that the matter has to be finally heard. We will admit it and post it to final hearing.
3 साल का टेन्योर 2.5 हो गया सर, इसको 2-4 के बाद रखिए तो इन्फ्रुक्चुअस भी हो जाए.
Infructuous is it?
क्योंकि ऑर्डर पास किया गया हमारे खिलाफ
टेन्योर हॉस्पिटल जाएगा
तो
होने ही पड़ेगा.
हमारे कैटेगरी ऑफ इंफ्रास्ट्रक्चर
3 साल का टेन्योर 2.5 साल इतनी कर दिया है. मतलब 2 महीने के बाद मतलब इनको रिलीज
We will
मतलब
place it after the vacations, July में. The matter, the case, the petition appears to be arguable and is admitted for hearing. List for final hearing in the July final hearing list.
the IR may kindly continue to business.
What is the IR?
The IR continues to.
by virtue of inter order she is continuing at the current place. मेरा निवेदन है
अच्छा.
इसको एडमिट ना करके ऐसे ही जुलाई में रखके बिठा दें.
My lord, कोई भी पश्चिमी को मैं भी लगा दिया, हमें कोई दिक्कत नहीं.
There is an interim order. If there is an interim order, urgency is expressed by the learned counsel for the respondent. And therefore list it on any Wednesday, Thursday in the month of May.
I have been happy.
I have to go.
We should like to go. Okay.
Number 21, the political party.
Which scheme? When was it directed? The learned counsel for the petitioner yet again praised the time to bring on record the Mukhyamantri Yuva Udyami Yojana scheme. Next, or accordingly, let the case be taken up after 3 weeks.
Number 22, Yaka Chaudhary.
Any urgency?
This would be Malor that is going to super advert.
When?
It's very nervous communication was. Metro CR was communicated. It travel club two different ways, rising out of two different periods of adverse communication, maybe back to back. And discuss the OA on the according to the finding of one OA, say that we cannot decide that beyond judicial ratio. This was the point. There are two different regional applications clubbed in one. Facts of one is dotted down, and it is this. Something strange. I argued this matter with common laws. I argued both the matters independently. And the judgment comes for not the judgments are clubbed together. Absolutely divergent matters are there.
The period is from April 14 to September 14.
There are two different periods now.
There's only one period.
The one period in this case was for not.
It was downgraded or what?
It was
Adverse. Adverse.
It was
By?
by the initiating. The reporting. Because Rmpssu reporting authority,
That
I
was-
say there was an incident which happened.
That was conquered by the higher authority.
It was one of the higher authorities says not that he cannot do that, but the reviewing authority of the state government. That point. Even otherwise, not, it has to be remanded back or segregated for the hearing of both the matters independently. The club together and common finding we arrived in. The grammar clubs a petition where cause of actions are different. Period of ACR is different. Rejection order is different. Altogether different issues has to be addressed. How can they club it and decided by a common? Rejection order is different. It has been rejected by a different authority. The reasons for rejection is different. The grounds of challenge are different. But a single point which is common in this.
So normally, comments of a reporting authority are difficult to interfere with. But if it's a- But if it's a downgradation or that,
Yes,
those things like,
certain downgradation or not, he has been an officer of entire service career is seen. I can reference to last 5 years, 10 years. The officer who has been graded outstanding.
when you say downgradation, it means what? You're comparing this earlier ACR.
Yes.
Earlier,
That
yeah.
has to be one. Man of extraordinary ability cannot be put below average or average, certainly within 6 months. If my career shows not the graph is consistent and I'm an officer who has been graded as good, outstanding, right? Throughout
Was that-
the last 10 years, 15 years.
Was that ground taken?
Yes, it was taken. But we just see the original application.
What is the OA?
The OA starts from page 28. Because of that, man, duly administrative grade didn't was deferred.
Where is the ground taken?
There are 4.16 page 40. Page 42, you know, the original application. There are 4.1, around 4.1. Sorry. Back.
What were the gradings in the prior year?
Where you're getting, one of just see a chart which I have prepared, but also try it.
You relied upon some Supreme Court judgment.
Yes,
Which one is it? 24th. Yeah. The matter has to be finally heard during, can be done during motion next month. And the case be taken up for hearing in motion on any Wednesday, Thursday in the month of July 24.
I'll take some time.
May will be this last week, last month before.
I'll take some second week of May.
No, you've listed lot many matters.
Third week.
That will be too close to the vacations.
Number 23, Janil Lala, Jeet Avasthi.
The supervising quality of the provided by the
Yes. What is the order that you are challenging? 6-1.
that is the order for I had challenged the registration of criminal case itself. The order was framing of charges.
Naming of charges.
The prosecution initially got started the prosecution on for offence.
November. ये criminal revision को नहीं लगाया.
Washing blood to be acceptable, therefore I have done.
You're seeking washing of framing of charges.
I'm seeking washing of the, I'm not challenged the framing of charges out of blood, I've challenged the case. My prayer is for washing of the criminal case against me.
Where is the FIR?
Lord, the FIR is at P5, page number 34.
You are named in this.
Yes. But the facts that the courts directly. Complainant Lord Look Singh is the husband of one Devi Rajan Lord, who is the president of that Saloon Lord, which is providing midday meals to the school Lord, which is coming within the cluster of the petition Lord. Petitioner duty is to visit the schools and check the quality of the food Lord. There are consistent complaints Lord, and it is the duty of the petitioner Lord to take down those complaints Lord and to prepare a panchnama and submit it to the authority. The petitioner prepared the panchnama of this school Lord, on which Lord he was continuously being threatened that if he submits those panchnama Lord, he will be falsely implicated Lord, and that was being done by the complaint is not by the Devi Rajan Lord, it is by the Trilok Singh saying that he has demanded money for running the midday meals and 500 rupees per month was the demand, which has been which he has alleged that it has been made by the voice was not clear, Lord. They could not identify the voice of the petitioner, so they consistently made prayers Lord to the court to direct the petitioner to have second and third time Lord. This honorable court, this matter has come to this honorable court earlier also. For this issue, that they wanted voice sample again, Lord, and this court has referred them. The trial court first print, and then this honorable court has watched that order, confirmed that order, Lord, and pushed the cost over the look. Not that you cannot ask for the voice again and again. If you are not able to get the case out of that voice, Lord, then you cannot insist upon for taking the voice again and again. That order was also placed by the Lord. They don't have the case was like this, not that they have approached the shop of one Anita Jain, who is the relative of the petitioner. There is a school teacher, not he was in the school when this incident took place. He was on duty on that particular day. They went to the shop, which is 1 kilometer away. From there, Lord, they say, Lord, that
this person will has conversation, and on that basis he has went to the shop and he has gone to the shop and he has kept the money over the table. Nobody has, the petitioner was not caught red-handed, not present on this. But that find that video clip also, lot of people who were standing around the market lot, they have taken the video clips and that video clip is also played on. So there were basic ingredients lot of the demand as well as the payment is missing lot. The whole case is concocted only with the help of the officers lot. And I have also narrated lot that there were certain persons with whom there was dispute of the petitioner lot and help the complainant lot in this whole exercise.
Yeah.
And the documents also.
Where is the charge sheet?
Charge sheet not as per the directions of the government. It is a coming memo lot. On 7/3, the lordship's directed lot, and I have filed it on 3/3.
So you are alleging mala fides, or you are saying that by reading of the allegations,
But
no,
Malafide is also.
no offense is made out.
By reading of this material, else is not, as they have created lot, it's made out. Otherwise, I'm alleging Malafide and I have created those officers also by them. Because this story lot, the petitioner was brought, they have got it from the school, they called it from the school. He came outside the school, he was picked up from there. He was not even present on the spot.
And where is
And
the
Anita Jain has also prepared a petition before the honorable court.
where is the transcript?
Not that is there.
P.
In the, along with the, coming number.
Page number?
34 onwards.
Started from 13 to 11.
Four, yes. बताइए, आप बताइए.
Firstly, your lordship, in the initial complaint, there is authorization letter of right of clearing. Who is running this from Bank of Jammu, the authorization letter is there, his name is there, thereafter your lordship, if your lordship will see this transcript. At page number 33-34, there is clear cut demand of 5,000. Here the demand of last lines of page number 33. And
Yeah. या आवेदक कौन है?
Avedak is the complainant and an Avedak is the
तो लग yes.
Lordship, I am reading from last 3 lines. Avedak is saying, बताने को आप ही को है, बता ही को है, हम कौन इतने पढ़े लिखे हैं, आ जाओ अनावेदक कौन लगा लो सब पुराने हम पढ़े लिखे हो.
No, पढ़ रहे हैं.
Last 2 lines on page number 33.
ठीक.
And how ऐसे हो then Avedak is saying इससे कम कहाँ हो गए, इससे काम कहाँ हुए, अब लगा लो 500 बड़े 12 मन. आवेदक कितने हो गए, तो आवेदक is saying 6,000. 6,000 है साल भर के आवेदक. अब 12 मंजिल साल 6,000, तो कम कर लो 6,000. अब साल भर के इकट्ठे तो देने हैं, ऐसा कर लो 5,000. 6,000 नहीं, अब इकट्ठे तो देने हैं, 5 दे देंगे. In starting your lordship from page number 32, he is discussing about that Panchnama. On page number 33. He is ready to not submit that Panchnama. He has made against the high copy.
And what you all
Covered from your lordship in that track.
No.
So, offense of section 7 is clearly made out. And the higher court has the section 13.
Thereafter there was no trap.
It was trapped.
Trap.
Money was recovered from. And the higher court has They charge him from the offices of credit.
What does the FSL say about this voice? Where is that report?
That the report is not there because there is no clear opinion about the jobs.
'96. Well, wise. Well, wise.
There was no definite opinion, and therefore they moved the report the court not to for every sampling of the voice note. And then that was dismissed, and thereafter they came to the council report, and then first was imposed on them that they cannot insist upon.
So it says that the questioned voice marked as so and so is the probable voice of the person whose specimen voice is marked.
They did not have a definite opinion that it is the voice of the applicant, and therefore not they moved the court saying that they want to read, again they want to take sample of the voice. So they are not able to.
No, if the report regarding the voice is not definite, then can't the prosecution go ahead with the trial?
They were not sure, and there, what I submitted is that there was no voice, there is no conversation with the applicant.
But they may not be sure. But in this given circumstance, can they go ahead with the prosecution or not? Or trial?
I'm being prosecuted, I say, Lord, I'm being harassed because they don't have material against me, still I am facing prosecution. And since 5 years. For more than 5 years, Lord, they have taken to file the charge sheet, and Lord, I am facing the difficulties of the prosecution. And
No, is there any law which says that if the expert's opinion is that we are not sure, it may be the probable voice.
they have come on various grounds. This is one of the grounds. And there are other grounds not saying that since there was one thing is that they could not establish that there was no trap in fact. They themselves say not that the money was kept on the table in the shop of Anita.
No, then you're going in for defense. That's your defense. Right now, we can only see their story.
Yes, sir.
We cannot see your side.
It is in their story that they have conducted the trap in the shop of Anita. Anita was not present there.
No, their story may be false. But if it discloses a particular offense punishable under PC Act, IPC, then that's the end of the matter. Unless, of course, malafide can be proved, because proving malafide is very difficult.
They have alleged malafide fraud and the officers are not before your worship, not forces are not yet. And specifically said that it is because of those officers not they not even I find also that clip lot, that video recording lot that the petitioner was not present on this one. It is in the shop, petitioner was at that point of time in the school. His attendance register is also good.
So if malafides have been alleged, against whom?
It is against the officers as well as complainant brought.
Trilok Singh.
Yes, Lord. Nobody brought. He is the husband of the person whom he says God is for whom the demand was being made.
And Santosh Kumar. Investigating. Where is the allegation of malafide in the petition against these two?
But 6.3 not absent. It is not conducted at the shop of Anita, neither the petitioner for proven on the spot. If I look at what action was meant to falsely indicate the petition.
This is your defense.
But I specifically said not that these officers are not in collusion with the I. In fact, from the Lord, I have said to him.
Where is that? To establish malafide, you have to There have to be pleadings.
Point nine if you also. What is 5.7 if you also, it's not 5.7, 5.9 actually. Then the one number two was working in the shop of police against whose fire was brought from hospitality. Sarkar then son of the prisoner, and we said that this was only in such offense by order of the prisoner, which co-accused Dargan Singh. That says one number two carried the intention against the prisoner, he colluded with Abhijit Singh and Dargan Singh, who were also in search of an opportunity to harm the prisoner. That the Abhijit Singh and Dargan Singh, using their contacts, one fabricated a fake claim wherein on rather this one but two went to the shop of a person to whom he had to pay amount for costs of clothes purchase. Not basis, not the offense is being made of. That's right. Fake raid was conducted not by them. He was discharging his official duties without he was one more thing, but I have filed one document law, that is an extra P2 law. जो पंचनामा है, that was already filed. There was no occasion for taking any money because that was done on 19/7/2018 itself. It was submitted before the competent authority, and therefore there was no occasion for the petitioner not to demand money. This is a government document law obtained under the RTI law, and it bears the seal of the authority. This is before the incident, just before the incident. Fights are made of not the rule.
So if they come forward and say that we did our job as a public servant and there's no malafide, then how do we decide it?
Whether the petitioner was present or not, that version would come from them.
No,
So,
no.
not even present on this.
Can we decide that right now? Even if we call for the reply, can we decide it? That may be your defense. I was not there. Defense of alibi.
What I said, not that both the ingredients demand as well as the reason should be proved. That should be established. That is not even neither there is proper because they don't identify the voices. Not neither there is a proper demand. Nor there is receipt because they think that the amount was kept on the table at the top of the emission. It is 1 kilometer far away from the school where it was on duty not at that time.
Ah, any citation? Any citation? No, that we have seen the expert's opinion as well as the transcript. That we have seen.
He has accepted the bribe. He has only said that put that money on the table.
All
And after that, you also phenolphthalein that was also came positive and the extent of phenolphthalein powder is there.
All right.
But,
Mr. Lala, any citation?
No.
Like. Which paragraph?
But there are 29 and 21. For the reason that in order to prove a case against the object, it was necessary for the prosecution to prove the with requirement that demand and acceptance of bribe amount by the appellant. As mentioned above, in this case, the prosecution, the charge of the appellant did not accept the bribe money, but the money was accepted and recovered from possession of Rajinder Kumar. In such circumstances, there is no interest to prove that the appellant actually accepted the money from the component. If positivity against the appellant and Rajinder Kumar paid, it cannot be held that money covered from the possession of Rajinder Kumar was money meant for the appellant for holding. And what Again, point with them, not that Anita Jain itself is also before the form report, that he can also. Right? She has also said about that it was money which was to be paid by that blocks in for goods purchased from her.
No, where is that petition? B10.
B9 without is the order, the petition is also pending.
ये आपको पहले बताना चाहिए था उसको साथ लगाते हैं. You heard the entire case and then you are saying that some other petition is pending.
That is why in the January there is said, but I don't know. Refer to the law.
Who is Anita Jain?
Mr. Jain is the one who in whose shop the money was returned. They say that he was called there and money has paid in the shop. But I mean, that was the accusation.
What is
He
the
said that's
lesson?
not my money, and he has also claimed that it was her money, which was to be given by the.
And in your case, the complainant is her husband.
Yes, same person. Same paradox.
And what is challenged here
See, because now.
in the petition filed by Anita Jain? What is she challenged?
He said her prayer is that the money which has been that money should be refunded to her and that what she is.
How does that help you?
Same stories there, not and she has said that it was her money which was to be paid by him and that was paid to her in the shop. So that money was not that was not with respect to the demand not been.
इसको बुला लीजिएगा. You will see if there is any relation. WP 20170 0170 of 22. Okay. You see.
Yeah, it's
All right.
Yes.
रिजर्व कर लिया उसको. तो देख वो ऐसा लगे कि हम सुनना चाहिए. उसमें तो अपने डिमांड करनी है. अरे पैसे वापस करो. Yes.
Number 24, Pradeep Kumar Sharma.
And there 2.0 is to undated subtracted 2022. Identity page number 20. But my matter of next month, writing out of the side. Only for the after matter. They have made a party to the mobile, that's why it is listed, but the relief party is concerned about they are changing the order of termination. No release to start against the mobile. It is relief against the department. Even the employee contractor and by the registration of the offense by the guy. Attractive selection.
ये DB में क्यों नहीं? देखो. case when the present petition does not assail any particular prosecution launched or contemplated under the Prevention of Corruption Act, but merely assails an order of termination. Passed on the ground of registration of an offence punishable under the peace law against the petition. In all probability, the present cause raised relates to the roster of single bench. Next, however, registry to verify and place it before the right bench. As early as possible.
नाम बताया था नंबर 25 तनवी खारिज
So Vikram Singh. Yes, Mr. Khare. A request is made for adjournment of the matter by the counsel for respondent prosecuting agency due to non-availability of the prosecuting counsel, which is not opposed by the others, at least after 2 weeks.
number 26 with connected matter
Same order. You are in 26.1. Yes, yes.
number 27
Yes. Same prayer. Yes, Mr. Khare. Same prayer, same order.
number 28 under Tiwari number 29 with Sanjeev Kumar Misra and Sumar Singh
For a contract concession agreement. Whether the section 34 would have set aside the award in question only on that ground.
We'll place it after the vacation on Wednesday, Thursday. The learned counsel for the parties do not dispute that the case has to be heard finally and can be so done in motion. Next, due to paucity of time, let the case be taken up on any Wednesday, Thursday in the month of July. For hearing and motion.
number 30 with connected matter is Saras Verma Akhilesh Kumar Jain
MCC क्या है? अच्छा. What is our consensus that the case has to be finally heard, which can be done during motion list for hearing in motion, any Wednesday, Thursday in the month of July. Yeah.
Case number 31, the other Gupta.
Yes, we taken of record and work application. The according to the order. Already admitted of finance.
It's IA for taking document on record to allow people. Accordingly stands disposed of both the IAs. The document shall be taken on record, shall be considered at the time of hearing. The appeal admit नहीं हुई है. कब admit हुई? अच्छा. Since the appeal is already admitted, so finally in the month of July. Service नहीं हुई. नहीं वो paper publication हो गई. Paper publication. I have to continue till the next.
नाम बताओ. Case number 32, Sanjay Kumar Verma, Rakesh Singh Gupta.
Yes. It has to be finally heard.
Yes.
If we find time today, we'll hear it. Pass over.
Case number 33, the Priyanka Agarwal, Abhijit Awasthi.
So not next week. Any urgency? Case is listed for final hearing, which may not be possible today due to large number of cases listed. Listen. Final hearing on any Wednesday and Thursday in the month of July. In July after vacations. Why? No, any urgency in them. Sanction on the ground of? Achha.
Cannot take place before the approval is taken from the state. So again, that means on both sides of the fact. That means the
Last week we have already listed matters. It has to be after vacations. Any Wednesday, Thursday in July. May not be possible.
Case number 34, Vijay Kumar Tripathi, Sanjay Yadav.
Why next week? Arguing counsel is not there. Mr. Yadav.
Not agreement.
Any urgency, Mr. Tripathi?
Same, whatever the interaction right now, by my word, there was a defeat of caste certificate without getting my caste certificate from the caste scrutiny committee. Departmental inquiry was conducted, and after departmental inquiry, I was dismissed from service. In this case, on every existing pertaining to caste certificate, no departmental inquiry could have been conducted. I said the judgment of the same bench of the tribunal, wherein the same tribunal has said that no discipline can be initiated on the basis of the caste certificate of the applicant. That judgment has not been considered by the tribunal and said that it is a distinguishable or it is a different one, but nowhere it has been mentioned what is the distinguishable feature of it. But I have also cited the judgment of Madhuri Patil, which laid down the procedure for conducting inquiries where the dispute is pertaining to caste certificate of anybody. If we take up to next week, very short issue is involved.
But these, all these facts have been considered in para 8 of the order.
Or in fact, they have not considered para 8 of the judgment, the judgment which I have supplied, now it is the judgment of Vitamulia. Wherein the judgment of Madhuri Patil has been referred to. Considering that judgment, the tribunal has held that in view of this matter, we are of the considered opinion that the respondent party could not have framed charge against the applicant pertaining to fraudulently obtaining the employment by producing false certificate without referring the matter to High Court Committee / Caste Scrutiny Committee in terms of the decision of in the matter of Madhuri Patil. Why this judgment is not applicable? The tribunal has not given any finding.
So we hear that is informed that the counsel for the employer is unavailable due to personal inconvenience. Next, for the list the case after 3 weeks.
Number 35, Simban
इसमें respondent 1 and 2. So what is the point?
Now,
That we have decided. We have said that the issue is pending before the Supreme Court. So we have said that let the Supreme Court decide that issue. And in the meantime, whatever law presently exists will apply in those appeal before the DRET. You can go to the DRET. WP number? 6402 of as grade 4 list along with MP 6402 of 23. That is on 15th, which according to the Learned Council for Petition is listed on 15th. List on 15th.
Bill number 36, Rajesh Rawat and Sabita Chaudhary.
So who is the for the other side? क्या challenge है इसमें? Rejected. With all the counsel for the other side, we are passing it over. We'll pass over and hear it.
Bill number 37, Shamantak Mani Shukla, Satendra Kumar Dubey.
Who is for the other side? None for the appellant. List after 2 weeks for the same purpose. And we'll see. Next time we'll see. Have they come? Or if you want, we can pass it over and last time I think it. 11-3 को तो थे ही। उसके पहले 2 बार नहीं थे। All right, we'll pass it over. If they don't come then.
Bill number 38, C Manoj Shukla, Manish Kolia.
All right, pass over.
Bill number 39, Kuman Singh, Sanjeev Kumar Mishra.
Can it be heard today? We have passed over 2-3 matters to be heard. It has to be some other day then. Matter is listed today for final hearing in motion, which may not be possible due to paucity of time. List the case for the same purpose, that is hearing in motion, on any Wednesday, Thursday in the month of July. Why? Significant amount means, is there a stay or something? No stay. You've not gone in for execution. Who has to go?
Just paying for any earlier date.
Why don't you go for execution?
Pecuniary ramifications of it.
What pecuniary ramification?
That would be required to be paid.
How much is the court fee?
2%.
2%. You are a company, you are not an individual.
I'm just paying for an early date.
We can't give you in May. Has to be in July. All right. July. Wednesday, Thursday, July.
First.
Bill number 40 with selected matters, C Kashi Pakruti, Kul Singh Yadav.
Okay. Finally.
but they are the same benefit. Maybe the promoting employees we are hiring every month we are one. All the employees are hiring passing time.
Mega Chandra's case.
You know, there's if a major change followed by a segment of the Rajasthan people
Mega Chandra is the earlier case. And which is the subsequent one?
Mega Chandra is the subsequent one. NR Parvan is the earlier. Similar issue was decided by the bench of Rajasthan. Was subsequently challenged.
You can't get seniority from a date when you were not born in the car. That is the concept. And if it is settled, then we'll decide. You are for? From a back date.
Yes,
Yeah, prior to your actual appointment.
cases like that, the seniority was already set. And the law which has been laid down, which has been clarified, that gives an exception that if the seniority has been settled,
Hmm.
then it shall not be disputed.
Okay.
Now the matter was heard at length by the lordship and then they came forward with a government part by Rajasthan. In that case, this point has not been touched. Now, here it has to be seen whether the seniority has been settled or not.
Any interim order?
There is an interim order in our favor, because what the family.
Where is that?
That was part below. The option was on. I just.
I don't think there is any interim order.
There is a several have observed that the respondents be advised. Because the government, the report they have for the segregation of things. 78 you lost a power and all. They enhance in regard to execution of interim order. Order of the 1718. Now, position is settled over for last more than nearly 10 years. They never challenged it. They were aware of this fact. No sooner the order was filed for the apex court, they started making representation, saying that now the position should be refixed, seniority should be refixed. So that is our ground. So that it's not a case for the first time this thing has happened. You never object.
So we have passed over a few cases for hearing in motion today. Oh, this may take some time.
It will
Please.
take time. This month, we are already. I don't fix it for final even time it might take.
No, that was heard by a bench of a different composition.
Yes.
But one request is there now. Two petitions, one of the petitions and two petitions are of unanimity. Some of the respondents are some of the respondents are represented by the administration. And some of the respondents are not being settled, noted as being issued petition. Some of the respondents need to be covered.
Which,
There is only respondents.
so in which case notice has not been issued?
Filed by the Union of India. Like, this is limited petition. That is 14.3 and 14.4.
40.3 is the MP, not review.
This is the petition, 40.3, 40.4. Some of the respondents are private, but not the private.
All the four petitions are arising out of the same.
If they say they are specifically, all the respondents said, I don't know. All the respondents.
In which case, all the parties are represented.
Okay. In every case, there are some of the private respondents are there.
In which case, all the parties are represented. Please tell us first.
Some of the respondents are there.
ये डिफॉल्ट साइंस में इसका क्या किया? 40.3.
Type copy the report, sir. In this petition number 40. The original report का report on that is why you move an application for removing the report.
You have moved.
Yes, sir, application.
Where is that application?
That application in the.
Ignoring default.
Yes, sir.
देखना है इसमें 256, 257, 262 तो अंडरलाइनिंग है legible copies 55 से
ID number object 13053.
40.3 में 55 से 66 देखो
Default of the place of the eligible copies of that copy already been filed in the petition number
5 6 with 66 then 85 98 85 98 85 so far as 85 is concerned your I is rejected 85 is not readable और बताइए
original record of the tribe, the certified copy of the tribe.
where is
All of the part of the record of the tribe.
where is that on 40
Certified copy. Petition.
85
Filed by the petitioner. पूरा record.
on this
Tribe.
what is what देखो 149 से 155 ये 149 से 155 देखिए सब ब्लैक है पूरा your letters documents
Part of the tribunal, certified copy for original document. It already been
so
filed.
it is though it is readable
I tried it. By taking the print of procedural number 40, it is 40.2 or 40.3.
readable तो है ये ठीक है
I ignore it. Within a week. Clear it.
सारे हैं 57 58 188 से 194 ये 188 194 रीडेबल नहीं है
I ignore it, doctor. My all is regular document.
इसमें लिखिए that though an application for ignoring default of a large number of cases being not readable has been filed but large number of pages large number of pages has been filed but considering the fact that that some of the pages admittedly are not readable and the learned counsel for the petitioner employer assures that the default shall be removed. The IA stands disposed of. The direction that the default be removed within 2 weeks, list thereafter.
But 40.3, 40.4, some of the have not been, it is not been issued, they are not been.
There are 8 sets of.
Are you representing them?
Had to find out one person who had responded before traveling. So for my concern, he was not included party to this kind of. And third, the respondents are those persons who were applicant before the travel. Now, what happened when at the admission stage, my friend appeared, he appeared, he is a teacher, two persons who were applicants before travel. So therefore, this was the reason that followed that notices have not been issued in either order. To the other respondents who have been.
इसमें लिखिए that इसमें किसमें नोटिस नहीं गया
किसी में नहीं सबने चूंकि अपीयर हो रहे थे एक्चुअली दो के ही अपीयर हो रहे पर ऐसा सबको इंटरेक्शन कि सारे रिस्पोंडेंट को रिप्रेजेंट
So, now they have to their matter on admission.
Hmm.
Then we will.
and then the matter was heard number of time and the interim order is there but since the other persons have not been listed ultimately we have caused the identical maybe some of them must have retired well that's
the council for the petitioners, council for the rival parties also informed that notices have not been sent in the connected matters to various private respondents. Next paragraph. In the petitions where the employer in the petitions filed by the employer, it is directed that the employer shall serve the private respondents on its own expense and a compliance report be filed. Most of this direction is given since some of the private respondents may have attained the age of superannuation and their current address may not be known except to the employer. Next, the aforesaid direction of serving the private respondents in the petitions filed by the employer shall be complied with in MP 4585 of 23 and MP 4588 of 23. Or a list in the month of July on any Wednesday, Thursday. Right.
Application of order. The interim order be kindly modified to up to the extent that status quo may be made. But they are keeping on holding the DPCs, and the direct recruits are being promoted one after the other.
that will be subsequent.
We'll take it up then we'll take it up a little earlier. List in the first week of May. You have their pension accounts. You must be paying pension to them. How will you serve? You will send somebody by foot, on foot. But do it through electronic means.
In fact, everyone is watching this case because department is also before this court. They are also there. It's not a case that we could apply. Maybe we are thinking like fancy have not been even photocopy or we read. कई बार सुनवाई हो चुकी है but my friends nobody is vigilant to come and because ultimately whatever stated but still nobody has get. It remains a base sentence of question.
Employer to serve through post or through electronic means.
So that interim order may be.
I have to continue. appeal.
The number 41.
You are relying upon this 2/4/24 order. 2/4/24. For using home, you are requesting for appeal number 2. Who is that? Naseem. Who is the main accused? इससे हुई है रिकवरी कहाँ से हुई? Who is the owner of the vehicle? Owner कौन है? ड्राइवर. And what is the sentence? 3 दिन. बताइए इनको कोई एंटीसीडेंट्स है क्या? क्या जब तो क्या जब आप कहाँ के रहने वाले? पंडित जी 24/2 के ऑर्डर पे कुछ अप्लाई करेगा या नहीं करेगा? 2/4 2/4 एंटीसीडेंट्स है क्या? क्रिमिनल एंटीसीडेंट्स के बारे में ऑब्जेक्शन में है आपके? इसका आगे को सही के लिए नसीम का क्या है? इसी के केस, इसके अलावा कोई नहीं. तो आपने वो रिकॉर्ड तो दिया है. अपार्ट फ्रॉम द प्रेजेंट केस और कोई केस उसमें नहीं दिख रहा. 2023 का है. वो उनसे कर दीजिए. All right. We'll grant bail. Same as 2/4. Yes.
Number 42. Sanjana.
Waiter. All right. 2 weeks as prayed for is granted to file objection. Take list after 2 weeks. Hmm? 2 weeks. We have granted 2 weeks.
Bill number 43, the Siddharth Dutt.
पासवर्ड सस्पेंशन ऑफ सेंटेंस, इसमें ऑब्जेक्शन आ गया आपका? ऑलवेज पास हो।
Bill number 44, the Vikas Mahavat.
टेरिटोरियल jurisdiction का है इसमें, पता नहीं टेरिटोरियल jurisdiction notice admit IR finding
Bill number 45, BSKP Verma, Ajay Kumar Agrawal.
yes. Yes, who has filed the application for custody of writing?
Marriage of my daughter.
It's 581. When is the marriage? When is it? In April. तो वेरीफाई कराइए बस। हो गया? वो पेश किया है कुछ आपने? क्या लिखा? No, there are two applications. One is for temporary bail, the other is for custody. Which one are you pressing? Both. The custody के बारे में क्या कहना है? लाल की छुट्टी। Present. And what about vehicle, Mr. Pandey? Yeah. ये कौन है? रजिस्टर्ड ओनर है क्या? The appellant. Awarlal. Any objection to the release? Orders and similar orders. Custody release. Have you brought that Supreme Court judgment?
Yes. Under my umbrella, I have to see it.
चल जाएगी मतलब नहीं हो Temporary bail will grant till when is the marriage? 18th. You will surrender by 22nd. Surrender by 22nd and 22nd April. Why can't you?
All the work I will have to do and settle all the forms which we will take for the marriage purposes. That is very much. I'm the only mother is
Yeah, who is getting married? Your
doctor.
daughter.
Doctor. Mother is expiring.
So marriage will be over on 18th.
All everything doctor.
That's why we're giving you another 4 days.
Finally, everything doctor.
Correct. Which funds? Funds would be spent till 18th. No further requirement of funds. Mama must have made all the preparation. All right, we'll make it 24th. 24th. Surrender. What must be the value of the motorcycle? 50,000. We'll say 50,000. Purity. Purity and security.
In my house, I myself collected vehicles, these vehicles also. If I was giving time also, I will do all the things. Vehicle also, I will only do.
Both these orders will be passed simultaneously.
Some little extended time. But if system is not.
No, 24th you'll surrender and the matter will be placed before the court on the week commencing 29th to verify the factum of surrender. We'll have to verify, do you have surrendered or not?
I want to be, and you have to give me a little more time.
So we've given you 6 days after the marriage, 5 days, 6 days. Good enough. What will you do after marriage except resting?
I will collect my vehicle and settle all the dues. Mama, करवा रहे हैं वहाँ से,
Mama.
लेने हम नहीं करेंगे. Okay, कोई नहीं. Then there is no one. Everybody is there. No one in the family. Imagine. Mama का तो नाम नहीं है.
These two.
Are you okay?
All right, 30th then we'll make it. 30th. And week commencing 6th May. Very fine.
Are you okay?
Right. Yes. Yes. We'll come back in 10 minutes. 46. How much delay is there? 3 days.
But according to us, it's also according to our,
Which is the order you are challenging?
probably that 16 wrong.
7-Eleven was disallowed.
But if it's not done that, there's actually-
It was wife's petition for divorce. Your petition.
Yes. Your files, on the 7 to 11, that was on, again, that, yeah,
That was allowed. आदेश 7 नियम 11 एवं 11 घ सेपरेटेड 20 के अधीन नामंजूर की जाती. It was rejected.
इस प्रकार यहाँ cheapest success maintain bargain that is really large enough.
7-Eleven was rejected. Where is that?
That was on page number 17 of option.
17.
Bottom of 7
So this was husband's petition. It was dismissed as time barred. Huh?
No causes.
No call.
on page number 7
And after time.
in the last amount.
Time barred. Hmm. What is the period fixed for challenging a arrangement?
Also, according to the certificate of the coordinate bank, the period is according to the JDBR, that was passed in 2018.
Hmm.
Order to take 11 in 2018.
Yes.
That therefore, they was also
Please. Brian will issue notice on delay as well as issue. Record be requisition.
Bill number 47, Sri Rohit Sharma.
Why Partha? Okay, husband's petition has been allowed. Then you delete. Time barred. Time barred. So we'll issue notice on that. Notice on delay as well as record be requisitioned. Notice within 7 days.
Case number 48, Arvind Kumar Singh.
Dismissed. All right. Notice record. Yes. Notice record.
Case number 49, Sankalp Kochar.
First thing we are not against order passed by the family court. Passing an order under section 14, an ex parte order in favor of the husband, allowing the application under section. Your lordships, this case, your lordships, the opinion against the decree of divorce was passed on 15 to 2024, that is, ISU P1.
Hmm.
Your lordships, in the case at hand, there were no notices that was served. Your lordship, the notices that were served were to his own address. And he was the one who rejected to take the your lordship's notices himself. Now, the order that has been passed in lordships has been passed on two grounds, that is, cruelty and desertion. Now, your lordship, his stance in the entire case states
This was ex parte order
your lordship is an ex parte.
against the wife.
Okay, lordship.
Why don't you go for 913?
Your lordship, we filed an application under order 907
Hmm.
for setting aside the ex parte.
Hmm.
Now, your lordship, in that case, and the same to the lordship on page number 34. The order passed that dismissing our application under order 9.
Hmm.
Then in our lordship, we had stated the fact that subsequently we got to know that there is a pending litigation that was going on. That we found out the notice later on in time. We inquired to our husband whether or not something like this is happening, and he told us nothing is happening and there's no litigation pending. So we took his word for it, and we didn't go ahead with the inquiry any further. So we didn't appear on the next date of hearing, and the next part of order was passed, and next part of proceedings were initiated. Now we watch it. The fact of the matter is the respondent in the case at hand is going ahead with another marriage record. And if he goes ahead with it, our status of wife would absolutely change our even our rights record. Only praying that the stay may be granted under the pending of this appeal here also on the order of the government developer. The lordship, the address on which the notices were served is his own address. We've been living with him during the entire process of the proceedings that were going on before the government work. That's a stance.
Notice we have 7 days. Record the requisition next. Meanwhile, the respondent husband is restrained from remarrying.
Case number 50, Tikhanan Singh Badel.
I would see executive appeal.
There is no delay.
delay नहीं है।
Delay.
शादी से एक ग्रुप का आवेदन लगाया है तब विवाह फॉर्म
Notice record. We have 7 days peremptory. Meanwhile, respondent husband is restrained from remarrying. You are appearing. Please so and so acts accepts notice on behalf of respondent. Sole respondent. Respondent husband. And prays for time to file power.
फाइल कर दिया आप देख 7 days टाइम टू verify या 31
Reply to IA 5830 of 24 an application. Next. All right, the copy of the memo of appeal. An IAS be served on the counsel for the respondent husband. Next. So we'll restrain you from remarrying. Don't remarry. Till then, don't remarry. Same order. Restrain from remarrying till the next date of hearing, list in the first week May.
Number 51, Shri Sushil Kumar Tiwari.
सर वाइफ की तरफ से ये अपील है
Same order. Notice, we have 7 days. Record. Meanwhile, respondent husband is restrained from remarrying. Yes, record will be called.
Number 52, we have to take up to the
Three होगा ना? 52
Yes.
51 था. First week of May गया ना?
50 नंबर 50 नंबर IR granted and notice record.
49.
49 में notice record IR.
Yes, 52.
Yeah.
Yes. 52 में क्या है?
perhaps again.
होगा. Any objection? Territorial? No. All right. Notice admission. IR. Final hearing.
Number 53, we have to take up to the
Same. में default है कुछ आप default remove किया आप
remove कर दियो.
तो दोनों में पेजेस एलिजिबल
नहीं वही ignoring कर रहा है. देखो
हम छेते हैं लेकिन एलिजिबल
21 93
हम भी एलिजिबल
103 116 116 130 0 वही वो भी एडमिट किया उसके पहले वाला उसको भी देखो तो देख लो ये वाला पता है.
Number 54, Janupam Bhatt.
Annexure Direction? One.
That is what ADM is. ADM looks like it has tried to consider voting.
तो execution का है, non-execution हो गया order number section 14. Within 30 days, if not already executed, and if there is no other legal impediment, वो एक order पहले भी हुआ है ये 14. इसमें वो add नहीं किया है impediment. कौन सा वाला हुआ? आप ही का था क्या वो? इसके पहले कौन सा था?
Say, right, 15, 21.
नहीं 15 जो हुआ है 15 में if there is no other legal impediment वो add होगा. चलिए. Dispose of.
Till number 55. Speaker Sharma.
Budget has been sanctioned by the state government. Allocation of budget is in process model. That will complete the last week of April. As per this scheme, I think the priority was not between dispersed. Whether has been allocated more, and 2 weeks time will be not possible. They have to. It are very much.
There's already order of the amount dated 23/20/24 minor. They will comply with the positive direction may be issued against minor, whatever the date they are asking minor. Why they have done, they will do positively minor. Whatever the date they want minor. Because now 2 installments are due, earlier 1 is due. 10/4/2023, 10/4/2024 is also over.
ये सरफेसी की proceedings का क्या हुआ?
But it has not materialized minor.
Not.
The option notice, the sale has not materialized.
The learned counsel for the state Shri GP Singh, आपने कुछ पेश किया है या oral instruction?
Followed the letter which I have received. The last date of it.
Armed with the letter dated,
So,
इसके द्वारा issued by
Subsequent to the minor order.
general manager of
Respond number 3 here.
the respondent number 3, that the amount of first installment sanctioned in March 23 shall be released when? प्राप्त होने पर, बजट प्राप्त होने पर लिखा है.
हाँ, सैंक्शन हो गया है. Various districts होना है.
बजट प्राप्त नहीं हुआ है अभी.
अभी डिस्ट्रिक्ट में नहीं आया. As soon as it is received in the district, it will be discussed as per the priority.
As soon as the budget is, as soon as the budget will be received. Next paragraph. The aforesaid assurance appears to be hollow, as the amount which was sanctioned more than a year back has not yet been received by the petitioner, which is a,
Right, an extra fee to my road.
who are you?
And the petitioner.
No. A company, what company? Which micro, mini, what?
Reason, we didn't block.
You are under that,
Under MSME scheme.
we कौन सी industry है? किस category की?
S block manufacturing.
Under the SMSME,
Under MSME.
which category of industry is there? It's a
It's
small or a mid, micro?
It is a micro, it's not a small, micro. It is 1 crore.
Micro, it's the micro industry. Therefore, the petitioner is constrained, and the petitioner is thus unable to start the commercial production.
Commercial production.
Is unable to meet out the financial implications of running of the industry, and also to repay the loan taken from the respondent number 4. Next, be that as it may, instead of keeping this petition pending, the same is disposed of with a direction to the respondent number 3,
1 and 3 both director.
1 and 3, to ensure the amount of first installment of 7,154,274 within bracket already sanctioned in already sanctioned on 10/4/23. To release the amount of so and so, then bracket which was already sanctioned on so and so for the petitioner, and report compliance. Latest by latest by 29th April, telling which this matter will be taken up as PUD for execution. All right, first week May, disposal.
Number 56, is Sunil Kumar Mishra.
Yes.
Modify the order of the, they are granted by the additional Yes, the hardship very possible condition has been inflicted. That is measure into sir. Case number concerning
32.
32.
Yeah, and what is the condition?
अभी जमानत आवेदन पत्र अंतर्गत क्या 47 तक प्रक्रिया संख्या स्वीकार किया जाता है और अभियुक्त को आदेशित किया जाता है कि यदि उनकी ओर से 2 लाख रुपए की सक्षम प्रतिभूति और 2 लाख रुपए का कर्म का निबंधन पत्र एवं एक अभियुक्त 10 लाख रुपए की न्यायालय के नाम की अपनी सत्ता के अंदर प्रस्तुत है तो सबको के साथ now they have been released on bail, sir. But the condition enumerated regarding the position of the FD, one is the 10 lakhs by the East. That is very difficult, sir. That's pending in this. modify or.
What was the, what is the offense?
Attachment of the vehicle in medical department, sir. Then
Why have you come under 482?
modification of this. Modification of this.
You can go to the same court. Seeking modification or deletion of any condition.
If the maximum, they are different factor. If the. Modification has been, needs to be. But by the level of this course.
After 15.3, have you approached that court which passed the order of bail?
You are not ready to modify that understanding.
No.
That is.
Have you approached?
That the written application regarding the modification of that matter has. The trial courts are always said that the review of the order which cannot be made by, which cannot be rectified by the same courts. That's why the petition has been filed on before the.
So where is that bar? That they cannot rectify the conditions subject to which a bail is granted. Where is that bar?
The classic. There is no bar person, there is no explicit provision having to notification of the order made by the state by courts. State criminal courts. Video.
You have deposited FD as per order. FD you have deposited. FD आपने डिवोट किया नहीं किया वहां पर? FD जो एज पर ऑर्डर है जिसको आप मॉडिफिकेशन चाहते हैं उसको आपने FD ट्रायल कोर्ट में डिवोट किया कि नहीं? नहीं तो आप फिर बेल पर कैसे उड़ गए? कंडीशंस थी उसकी।
और आप अभी एक मिनट, आप अभी जेल में हैं या छूट चुके हैं? Released. You have complied with the condition.
Relaxation has been granted by the court to unseat that.
कहाँ है उसमें, कहाँ ऑर्डर्स में कहाँ है ऐसा? तो फिर
आपने कहाँ लिखा है कि आप रिलीज हो चुके हैं?
इसमें सिर्फ लिखा है लेटर आंसर पुलिस से।
पढ़िए पढ़िए पढ़िए।
उनकी ओर से जमानत का प्रत्यय आरोपी को जमानत पर मुक्त किया जाए। क्लास लाइन
उसके बाद कुछ भी नहीं।
आप जमानत पर रिहा हो चुके हैं। वो आपने वो 10-10 लाख का एफडी पेश किया है नहीं किया?
कहाँ लिखा हुआ है इसमें?
ये ओरल है या इन राइटिंग है? ये एफडी जो है 10-10 लाख की, इसको मतलब वेव कर दिया उन्होंने, माफ कर दिया है। कहाँ लिखा है सर?
So agree with Laksik sir. इसमें बात की जाए लगी है और ठीक हुई है।
नेक्स्ट पेशी कब है? जब खत्म होगा।
Yes, yes, ये तो उसका है चालान फाइल है ट्रायल मोड ये चालान फाइल हो गया चालान फाइल है
ट्रायल कोड
हाँ हाँ
पता करके बताइए you have been released then what pass it over pass over कर रहे हैं बताइए पास ओवर कर रहे हैं लंच के बाद आएगा यस पास ओवर कर रहे हैं लिस्ट के बाद आएगा लंच के बाद आएगा 3-4 बजे आएगा आज ही आएगा
Bill number 57 with connected matters, Yashok Lal Mani, Siddharth Sharma.
It may not be possible because we have kept some first appeals in past. So this matter has to be finally heard in motion. But due to paucity of time, the same may not be possible. Just for final hearing on any Wednesday, Thursday in the month of July.
Bill number 58 with connected matters. Raghav Singh Thakur.
Matter was directed to be tested.
Keep
commencing. He. Do not know what has done.
Or it is in additional call.
By which the order is probably 6.
Take an additional call.
No, but has that Supreme Court decision been up? No, has it been uploaded? So we'll take it up in the next week. We'll take it. Let the order be uploaded. Then we can.
Yes.
That the website of the Apex Court reveals that the review sought of the decision in the case of Devesh Sharma versus Union of India has been pronounced, but the order has not yet been uploaded. Next, awaiting the uploading of the order. The review by the Apex Court list in the week commencing 15th. 15th April.
Please note of the petitioners. I appear before the Honorable Supreme Court on behalf of the petitioners here in Manoj.
Only the last paragraph. It is only the last paragraph that we'll be reading.
Could I clarify, Manoj? I am for the petitioners.
Probably there is some date given that subsequent or prior to this.
If I can explain, Manoj, I'll just take 30 seconds and I can explain. I was appearing for the petitioners herein before the Honorable Supreme Court, Manoj. May I, Manoj?
Will the uploading take so much time?
Manoj, the reason is that one of the Honorable Judges is retiring today, Manoj. Therefore, there was some delay, Manoj. We have checked with the Honorable Court's registry. By today, the order would be uploaded. But the fact remains, Manoj, that which everyone will join hands on is that wherever there was a subject to order passed by the Honorable High Court, all those appointments will go. So wherever appointments have been made and a subject to order was passed in various high courts, all those appointments will go.
Just a minute, Mr. Kalwar. We have to follow the Supreme Court order, that is all. We don't require any research in it.
Indeed.
We don't require any extra effort to see what the Supreme Court says.
That's what I was saying. Otherwise, me and
I'm opposing any kind of adjournment, Manoj. The Honorable Uttarakhand.
So why would we require the assistance of the Advocate General when everything is settled by the Supreme Court?
So grateful.
There are certain qualifications made in that paragraph.
We follow it as it is. We leave it to the state government to follow the Supreme Court judgment, that's all.
Very well.
Now, whatever is uploaded.
My lord,
In fact, the Uttarakhand High Court had followed the Divesh Sharma judgment retrospectively, came in SLP, Supreme Court has dismissed it on the very same day, Malaj. The Honorable Supreme Court following where an SLP was filed against the Uttarakhand High Court, making the judgment retrospective.
Just on 15th April. 15th April.
Malaj, can I just make one request if my lords would?
Yes.
No further adjournment, Malaj. The matter has been pending since 2022, Malaj. Can that one line come if possible, Malaj? That no further adjournment could be sought.
Now, this development is that the Supreme Court has settled the issue. And there is no question of adjournment, obviously.
Because, yes, the Supreme Court has only clarified that whatever appointments have been done prior to Divesh Sharma will stand in case there was something.
Let the order be before us. Then
Very well, we'll produce it. We'll very well produce it.
Yes.
Deeply grateful.
Yes, I have to continue to the next.
my lord, so MA diary number 4303/2024 लॉर्डशिप, ये डायरी नंबर लॉर्डशिप अलाउ हुई है लॉर्डशिप, जिसमें क्लैरिफिकेशन था स्टेट गवर्नमेंट की तरफ से लॉर्डशिप। इसका ऑर्डर अभी अपलोड नहीं हुआ।
15 तारीख को आपको सुनेंगे 15 तक।
लॉर्डशिप, हाईली ऑब्लाइज लॉर्डशिप।
Pass over matter, bill number 3, Vikesh Pratap Singh. The corrected matter.
Not well. तबीयत खराब है। इसमें ऑब्जेक्शन आ गया आपका? ऑब्जेक्शन फाइल नहीं किया? अच्छा, फाइल किया। ये क्या नाम है आपका? Veda Chaudhary informs that arguing counsel on behalf of appellant is unwell. List after 2 weeks.
Bill number 4, Rajendra Kumar Banska.
Same order.
Bill number 5, Surendra Pratap Singh.
None present when the case is called in the second round. No one is present when the case was called in the first round. None is present when the case is called in the second. To afford an opportunity to the Union of India to be represented, list in the next week.
Bill number 6, Rajesh Kumar Srivastava, Smita Verma.
Yes. No, let us finish with the passovers. Then we'll take on this case. Yes.
Bill number 14, Ramesh Chopra.
Fresh case. It's a fresh case. Yeah. Removal order. OA has been dismissed. Limitation. That's 7. No, he has not made any such objections right now. No, probably when he saw that you are not there, he stood quietly. He did not make any such objection. हाँ बताएं. Yes. आप ready है ना? बाद में don't seek time. No, why should we issue notice? It may not be worth issuing notice also. So let us first find out on admission. Yes. So the removal was 16/11/2004.
Page number 3 of the. On 1/6/2001. Is suspended from service. This paid an insignificant amount of ₹106 per month as suspended. That is literally given from 2001. Then lot on 7/8/2001, criminal case was registered against the petitioner at police station sector 6 at July by crime number 38800. I was granted anticipation. Then on 2102, I was given a charge sheet. Then evidence was recorded, उसमें सारे merits we can go only later on. Removal order item number 4, 9/6/2004. Removal order is passed. After removal order, had not been paid a single penny. This is my specific condition. Over there also in here. So, Lord, from 1/6/2001, I was getting a monthly maintenance around 106 to 550 only. Till my removal order dated. Now, Supreme Court will come to my rescue that if you are not paying proper salary or proper suspension, then the entire inquiry is issued. That judgment is there. Now, Lord, after removal order is passed, appeal is dismissed, revision is filed, then revision is filed on 12/3/2001. Now, how shall I move with tribunal at that time? I did not move tribunal at that time. I waited for the acquittal of the criminal case. The criminal case acquittal item number 7 takes place from 4/8/2018. And thereafter, my personal problems, petitioner's wife expired, and they had three unmarried daughters, all those problems have specifically pleaded. And the petition OA has been dismissed on the ground of delay. Now, Lord, when representation 24/2020 representation of petitioner for revision in view of his acquittal order was passed. जब जैसे ही मेरा acquittal हुआ, I find the revision that same matter I have been honorably acquitted. So I came to know that the appeal has been filed against my acquittal order, and the appeal was also dismissed, item number 11 on 31/5/19. And then I filed on 1/9/19 instant. Lord, when I filed this application under section 19, notice was issued, return was filed, matter was argued on merits on a number of pages. And then finally, Lord, on the date of the decision not 2/2024, it was dismissed on the ground of delay. My first argument, Lord, before the level tribunal also was that when once notice is issued, return is filed, and matter is argued on merits on a number of dates, then this honorable court in a writ appeal, Lord, which I have myself argued, that I am giving copy to my Lord just now, that when matter is notice is issued, matter is argued on merits on number of dates. It is not in the interest of justice to dismiss the case on the ground of limitation. This is not proper. This is what the opinion of this honorable court is. Then, my Lord, there is another thing. There is one ground which I have taken in my writ appeal also.
Which is the removal order, Mr. Arun?
Pardon?
Which is the removal order?
The removal order. Lord, on those self-same charges, I was also subject to a criminal case.
Hmm.
So there are so many Supreme Court judges, I said,
I would like to see whether the removal was based on a conviction only or not,
no,
or the criminal charge or not.
no, it was not based on.
There was a departmental inquiry.
That
there.
was it. What is there, I can't. It is not at all based on me. Some Lord.
So then probably the limitation will come in your way. Then probably the limitation will come in your way. We'll take it up after lunch.
Some of the items you can see, pending.
Identical to which case?
Number
Item 58. दे दीजिए आप लिस्ट दे दीजिए along with so and so.
Yemengar one, Hindu party.
But in this case, on last, companies have time to go through the record. I have filed the application for verification of records. Once it came, that time I was in the hospital. And the second time I have filed the application, but I couldn't see the. Couldn't verify the.
You want to inspect the record or arguing on IA?
So what happened actually on last occasion, it's exhibit 7, I was referring to exhibit 7, but that was not in my mind, but it required something, I couldn't answer, that is why.
How much more time do you want?
1 week's time. Application is there, I will verify it.
Then you take 4 weeks. इत्मीनान से अपना रिकॉर्ड देखिए. बार फिर वो लिस्ट होगा. The learned counsel for the appellant takes further time to inspect the record for arguing on IA number sums. Right. List after 4 months.